Good afternoon, everyone. My name is Mike Strozinski, and I'm the Executive Vice President and General Counsel of Massachusetts Health and Hospital Association. Thank you all for joining us today. On behalf of the MHA team, I'd like to welcome you to today's webinar, Steward Health Care Bankruptcy Update. A few logistics before we start. If you have questions during the webinar, please enter them into the chat feature, as we are in a listen-only mode. The questions will come directly to us, and we'll do our best to address as many as we can either during or prior to the end of the presentation. I also want to take a moment now to thank MHA's 2024 annual sponsors and strategic business partners for their support in underwriting today's webinar, which is just one of many events we have to offer throughout the year to connect our members with leading experts on timely issues such as the one today. I'm now pleased to introduce our speakers from Manatt, Phelps Phillips, LLP, Eric Gold and Schuyler Carroll. Eric is a healthcare partner and leader of Manatt's Boston offices. His expertise lies in government and internal investigations, state regulatory matters, and health policy engagement. He uses this experience to advise public and private clients on issues involving healthcare access, insurance coverage, behavioral health, and more. He's well known to many in our audience today for his prior role when he served as chief of the healthcare division at the Massachusetts Attorney General's office, where, amongst many other accomplishments, he played a key role in major litigation efforts to prevent federal health policy rollbacks that would have limited access to healthcare coverage for Massachusetts residents. Schuyler is a partner at Manatt, Phelps Phillips, who specializes in guiding clients through complex bankruptcy proceedings. Primarily focusing on Chapter 11, 15, and 17 cases, Schuyler provides solutions and litigation support for bankruptcy restructuring, transactional matters, distressed acquisitions, and creditors' rights enforcement. He represents a variety of clients, including debtors, creditor committees, claims traders, and more. Schuyler also has extensive experience in state and federal courts, litigating creditor rights, enforcement actions, and fraud claims. We're grateful to have both of them with us today to discuss this topic, which is on the minds of everyone in our healthcare organizations around the clock right now. MHA and our members continue to work daily with state leaders to respond to the ongoing situation at Steward and to prepare for any scenarios that might come our way in the coming months. So we really appreciate this opportunity to feature the voices of two experts to help ground us in the mechanics of what this bankruptcy process entails and how it may inform the future of our healthcare ecosystem. I'll now hand it over to Eric and Schuyler to get us started. Thanks for joining us.
Well, thanks so much, Mike, and to everyone at MHA, thanks for having us and really appreciate the kind introduction. My name is Eric Gold, and as Mike said, I'm a partner with Manatt in our Boston office. Can you advance to the agenda? There we go. So we're going to talk for a little bit today and then do encourage your questions in the chat, and we'll save some time at the end to talk about them. I'm going to talk first, talk about the history of Steward, a little bit to ground us, and then the Massachusetts regulatory process that is going to come into play here as Steward is trying to sell its physician group practice as well as its Massachusetts hospitals. And then I'll talk a little bit about the state of Massachusetts role in the bankruptcy, that is the Commonwealth's role. And then Schuyler will talk for a few minutes about Chapter 11 bankruptcy overview, the Steward bankruptcy filing, the role of creditors, the claims process and financing, and then the sale process as well, which I know lots of people are interested in. Okay, you can go to the next slide. So to reset, right, Steward started in Massachusetts about 15 years ago when it acquired the Caritas Christi healthcare system. Those were the initial 6 hospitals in 2010. Then it acquired the Quincy Medical Center, and then Morton Hospital and the Neshoba Valley Medical Center, Merrimack Valley in 2012, the New England Sinai post-acute care hospital. As is noted on the slide, 3 of those hospitals have already closed. Quincy several years ago, New England Sinai earlier this year, and Norwood Hospital that closed during COVID and is in the process of being rebuilt. But as of today, there are I guess depending how you count the Holy Family and Merrimack Valley Hospital, now two campuses in Methuen and Haverhill, the same hospital system. So really 8 hospitals that remain open. Next slide. So it's also important to note that Steward's financial challenges are not recent. The Caritas Christi system was struggling when Steward started, when Steward acquired it, and going back to 2015, The Attorney General's office that was monitoring Steward after its acquisition of these nonprofit hospitals, remarked on its continued financial struggles. Um, the 2015 report from then Attorney General Coakley's office found that the financial condition of the Steward system had declined since 2012 when it completed its acquisitions, that the system had increasingly relied on bank term loans to fund its operating losses and capital expenditures, which led to a capital structure where its debt exceeded its equity by several multiples by the end of 13, and that the health system's ability to meet the requirements of its lenders and investors may be an important challenge going forward. And that's obviously come to bear over the last decade. Next slide. So with those financial challenges already in place in 2013, 2014, Steward then sold its Massachusetts hospital facilities to Medical Property Trusts, which has added an additional layer of complexity to the current situation. MPT actually first bought the real estate for Good Sam, Holy Family, Methuen, Morton, St. Anne's, and St. Elizabeth's for a total of about $600 million. And then a year or two later, Steward initially mortgaged, but then ultimately sold the real estate for the Kearney, Holy Family in Haverhill, Neshoba Valley, and Norwood for an additional $640 million. And then at the time, entered into what were 15-year leases with additional automatic annual rent escalations. So those rental payments were set and then increasing every year. So it's about, more than $1.2 billion on the sale of the hospitals with those significant rent payments each year as well. And next slide. And then really in the last 4 years, the financial situation continued to decline. These are just some of the headlines. This recent headline from the Wall Street Journal in the upper left reflecting a $400 million deal that Cerberus did with MPT that put further financial strain on the company. Then Cerberus's sale of Steward in 2020 back to the management, and then it's starting to market the hospitals in early 2024 and ultimately bankruptcy filing. And you can see all this if we go to the next slide, just a little timeline that outlines where Steward has been, where it started with the acquisition of Caritas Christi in 2010, up through the bankruptcy filing last month, May 2024. Okay, we can go to the next slide. So here's the key state agencies that are involved in regulatory process when you think about acquiring or selling a physician group and hospitals. It's the Department of Public Health, the Health Policy Commission, and the Attorney General's office that each have separate processes but work together. So, or in coordination at least. So the Department of Public Health has what's called a determination of need process. Any facility that is a healthcare facility, including hospital, that is going to be changing its ownership, needs to apply for a determination of need approval. Following the application, the Department of Public Health staff, sometimes in conjunction with an outside independent assessment, will make a recommendation, and ultimately the Public Health Council votes to approve or reject a determination of need application. So that's the DPH role. Many of you are familiar with the Health Policy Commission, which is the newest of the Massachusetts state agencies created by Chapter 224 in 2012. And HPC has a process that starts with something called a material change notice that's filed 60 days before a change of ownership for any provider or hospital. The HPC can elect, after reviewing the MCN, to conduct what's called a cost and market impact review if it finds that there's a likely significant effects on the overall healthcare market from the proposed transaction. But importantly, coming out of that review, the result is a written report that the HPC may refer to the Attorney General, but the HPC doesn't have authority to stop any particular transaction, whether it's a physician group acquisition or a transfer of ownership of a hospital. The Attorney General, as you might guess, has the authority to enforce state and federal antitrust laws. The AG's office can investigate. That means demand documents and data and records from the merging parties and other entities that may have relevant information. And it can also take depositions, that's force witnesses to testify under oath about a proposed transaction. Um, but like in some ways, like the HPC, the Attorney General's office doesn't have the authority on its own to stop it. But it does have significant authority in that it can file a lawsuit asking a court to halt a proposed merger. And the AG's office may also negotiate, agree with the parties to allow a merger to go forward with certain conditions in place. And you've seen those examples in the past. The AG's office negotiated conditions with, for example, Beth Israel and Leahy at the merger that formed the BILH system. And the Massachusetts AG's office filed suit to halt the then partners' proposed acquisition of South Shore Health, which the parties then elected not to move forward with after the suit was filed. You can go on to the next slide. Um, so here's where the regulatory process is at the moment with the Steward transactions, right? So Steward in March, Steward and an affiliate of Optum filed material change notices to the Health Policy Commission, summarizing their proposal for Optum to acquire the organization known as Stewardship Health, which is the Steward Physician Group. Steward and Optum said in that notice that they've also filed required federal antitrust notices. Those are known as Hart-Scott-Rodino notices that are required of not just healthcare combinations, but any mergers of entities over a certain dollar value. There has not been and would not be a DPH-DON filing with the physician group. On the hospital side, there have not been any notices filed yet or any sort of beginning of these regulatory processes, at least not publicly. No material change notice has been filed with the Health Policy Commission. There's not been any public notification of an antitrust notice, although in the bankruptcy court, Steward's lawyers have said in open court that they are coordinating with the Department of Justice, and the implication being that the DOJ and presumably state antitrust regulators are reviewing potential mergers there. There's also not been a DON application for change of ownership as to any of the hospitals. If and when that happens, the applicant would have to meet the standard under the determination of need for showing that there's a need for this change of ownership, that the new owners will comply and meet the cost containment goals of the Commonwealth, all the licensure requirements, and that the new owners have sufficient funding to operate the hospitals. Next slide. And then just to note, in addition to the state's role as regulator, the state has an active role in the bankruptcy itself. So the Commonwealth has hired an outside lawyer who's appearing in the bankruptcy court on the Commonwealth's behalf. Unusually, the Commonwealth has multiple stakeholders, multiple agencies that it's representing at once, including the Department of Public Health, Mass Health, and the Attorney General's office, right? So as I said, with DPH, they are the licensing agency, the regulator, but DPH, as you all know, also plays an important role to ensuring that Massachusetts hospitals meet state and federal health and safety standards. So the lawyer before the bankruptcy is advocating on that behalf, on that point. Mass Health has a direct contract with Steward, which operates a Mass Health ACO, serving 100,000 members in 18 different service areas. Through those members and also for fee-for-service members, Mass Health has paid Steward, according to a filing in the bankruptcy court, more than $350 million in reimbursements, incentives, and other supplemental payments last calendar year. And the Attorney General's office, in addition to its antitrust review, is the chief law enforcement officer. The Commonwealth has authority to enforce civil and criminal laws across the board. So you can see on the next slide that the Commonwealth is really advocating trying to bring together all of these agencies and authorities to advocate for the Steward hospitals to remain open and for the time during this process for the state regulatory process to proceed. It's advocating for the hospitals to stay open, includes advocating for workers and favoring requests from Steward that allow all the hospital employees to be paid, including those paid over the threshold that required specific approvals from the bankruptcy court, ensuring that Steward has access to its bank accounts and that it has getting financing to pay its employees. The state has also been advocating to ensure the health and safety of the Steward hospitals, including coordinating with what's called a patient care ombudsman that Schuyler will talk about. And the state has also been clear in asserting its authority to review and, where appropriate, legally challenge or approve any proposed sale. It's also worth noting that the state's counsel in its initial filing noted that in 2021, Steward had paid its owners $111 million in a cash distribution, seemingly an important part of the state's attempt to hold Steward's ownerships accountable for the bankruptcy. So I see there's a bunch of questions in the chat already, and we'll, I think, try to get to those at the end. There's, at the moment, I can, why don't I wait till I'll let Schuyler go forward, and I'll sort of try to get to those at the end. So you can go to the next slide, and Schuyler will talk about the bankruptcy process, then we can come back and answer some of these questions.
Thank you, Eric, and good afternoon to everybody. So as you can see, the Steward filed bankruptcy really for the goal of selling its hospitals and its physician group and to obtain the time necessary to do that. In general, the goal of a Chapter 11 is exactly that. Sometimes it's to try and restructure the obligations. Here, their goal is really to sell. And the purpose of the Chapter 11 here is to utilize the special remedies that the Bankruptcy Code gives, and I'll talk about those in a little bit, but also to stabilize where they are. There were lots of lawsuits, lots of investigations, and lots of problems before the bankruptcy filing. The Bankruptcy Code provides what is called an automatic stay to all actions that are pending against Steward or anybody else who would file bankruptcy, and prohibits any new actions from being commenced. So, for example, a lawsuit to collect money, a lawsuit to evict, or any other actions that somebody would take against the debtor, Steward here. The second thing is it maintains the status quo. Because nobody is permitted to do anything, in certain cases, the creditors might be taking actions that would harm other creditors. The bankruptcy allows for everything to be put on a level playing field and essentially on hold and maintain the status quo. The important stakeholders here, I'll talk about them in more detail in a minute, but as you might imagine, the lenders, the landlord, the trade creditors, vendors who work with the hospitals, and because it is a hospital, the patients, as well as regulatory agencies. Financing is very important and is often the driving force for the timing of a bankruptcy. And in this situation, that was one of the important reasons for the filing, the timing. Here, they essentially had run out of money. They were losing money in their operations, and they needed to borrow new money to continue operating. They were at a point where no one was willing to give them money in the ordinary course, and so they had to resort to bankruptcy. One of the powers of the Bankruptcy Code is to permit an entity like Steward to get financing on terms that provide significantly better protection to the lender than otherwise would be available. I'll talk a little bit more in depth later about the financing here. Another important part of a bankruptcy is the appointment of a patient care ombudsman. And just as the name indicates, that is a party who is experienced in healthcare and has the looking out for the patients and their benefit to make sure that the bankruptcy and or sometimes the lack of financing does not result in a negative, does not negatively impact the patients. If that is the case, the patient care ombudsman is authorized to come to bankruptcy court, issue a report, and tell the court what they think needs to be done, and the court can take action. Next slide, please. Why was Steward left with no choice? Here, I mentioned before that they needed financing. The reason they got into that situation, Eric talked briefly about it, was their enormous debt load. They had several different groups of lenders that had secured claims, meaning a lien on their assets. They had hundreds of millions of dollars of vendors and trade claims that are owed money and unpaid. And they had their landlord where they were racking up debt as well. The post-petition financing that they've obtained will add to that debt load. As I mentioned, the stakeholders here, the only other thing I want to point out is because this is a hospital, different than your typical bankruptcy, the patients and the patient care ombudsman, their interests come into play. It's not simply an economic question. Courts will take into account the ability of the hospital to operate properly for the benefit of the patients. Goal, as expressed by Steward repeatedly, is to keep all of their hospitals open. They have begun a marketing process for all of the hospitals. Some of them that process began before the bankruptcy, and for their physician group, Stewardship Health, that was begun before the bankruptcy, and they even had an offer from Optum before the bankruptcy, as Eric talked about. In the bankruptcy, they're going to hope to obtain bids and hope to obtain approval from the bankruptcy court for those bids. Why do that in a bankruptcy court? The bankruptcy code gives additional powers to a debtor like Steward who wants to sell its assets. In particular, in regard to a sale, the bankruptcy court can approve a sale in what is called free and clear of any liens, claims, or encumbrances. So to give you a simple example, as I mentioned before, there's a huge debt load here. It's highly unlikely that any bidder is going to be willing to pay more than the debt. Outside of a bankruptcy, the creditors would be able to simply say no to any sale that does not pay them in full. In a bankruptcy, however, the court essentially divides up the situation into two different pieces. One, the sale, and two, the reconciliation and payment of claims. So the bidding process, the marketing process proceeds, and whoever is determined to have the highest and best offer will be the successful bidder. The money they pay will come into the bankruptcy. It's referred to as the bankruptcy estate. And that money will then be held for later distribution and allocation among all of the various parties. And in this case, there are significant issues. You have not only the secured and unsecured, you have the landlord, and Medical Property Trust believes that they have significant claims that may trump both the secured and unsecured. As you'll see there, this is not a situation where the bankruptcy court can just ignore the regulators. The regulators will get the opportunity to step in and, stewards hope, approve the transaction, but it is not simply a rubber stamp just because the bankruptcy court has approved it. The regulator's role sometimes can be a little bit different than outside of bankruptcy because the regulators understand the situation, which is that if the sale is not approved, or to say it differently, the bankruptcy court has already approved the sale, and if the regulators do not approve the sale, there may be the possibility that the hospital will shut down. So that may be in the back of the regulator's mind here. Next slide, please. The physicians and other creditors do have a role here. Generally, the secured creditors are taking a very active role. They have counsel, they have financial advisors, and they will participate in every aspect of the case. The landlord is doing the same thing, and creditors are represented generally by a creditors committee. That's a group of about 7 people, all of whom are creditors, people in companies, I should say, all of whom are creditors, and they have different roles in the case. So they are generally supposed to be representative of the other unsecured creditors. For example, there are a couple of healthcare companies that have provided services to Steward, and they're on the creditors committee. The creditors committee also takes a very active role. They have counsel, they have financial advisors, and they are participating in the sale process, the marketing as well. The physicians have a role, but their role, unless there is an issue, generally is not as active as the others. They can come to court, they can raise any issues, and particularly if there's an issue they believe goes to patient safety, they can raise that and they can work with the patient care ombudsman to bring that to the level of the court's attention and to ask for change. The claims process. There are really 2 parts of the claims process. One is creditors, the vendors, the unsecured creditors, the landlord, the secured creditors, physicians, anyone else who is owed money, either from the past or in the future. For example, a vendor may have a long-term contract, and that contract may not be something Steward wants to continue with or a buyer wants to continue with. In bankruptcy, one of the additional powers is the debtor can reject contracts, which is akin to a breach of a contract and gives rise to a claim the contracting party can assert in bankruptcy court. And that's one side of it. There is a deadline for those claims to be filed by August 19th, meaning anyone who believes they are owed money needs to file a claim by that date. Certain claims will be exempt from that. For example, if it's a claim that arises after the bankruptcy, or if it's a claim that arises from rejection, which takes place after August 19th, those will have a later date. The other side of the claims process is claims that Steward in bankruptcy can bring against other parties. For example, I saw there was a question about auditors earlier. Steward could bring a claim against its auditors to the extent they did something that they shouldn't have done or missed something, and it harms the creditors. The creditors committee also has the right to, under certain circumstances, bring those claims. Another claim that they might bring is a claim against Cerberus to try and recover the hundreds of millions of dollars that they've been paid. Sorry about that. Post-petition financing is, as I mentioned, what drove this company to file bankruptcy when it did. They needed money, and they were able to borrow on an interim basis from their landlord, Medical Properties Trust, MPT. The terms of that, however, had two different parts. One was approved on an interim basis on the first day of the case, and an additional one was objected to at that time. So the court delayed that, and ultimately the debtor Steward agreed to withdraw that. In its place, Steward got approval to seek alternate financing, and they are in the process of trying to do that now. Next slide, please. The sale schedule and the process going forward, we have the physician group with the proposal from Optum. We have the hospitals broken up into two different groups. The first is including all the Massachusetts hospitals, and that is on a schedule now that will take us through the end of the end of July. Originally, that process was a little shorter. Steward went back to the bankruptcy court with the consent of the major constituents and extended it by about 3 weeks. The Florida hospitals are the second group, and that should end by early August. As I mentioned, the state regulatory and antitrust reviews will continue. It's not exempt because it's in bankruptcy. And then the process will require a transition to new owners. Typically, in a bankruptcy, the process requires significant delay after the bankruptcy court approves the sale to obtain state and other regulatory approval. Because of that, buyers typically enter into a transition services agreement that allows the buyer to begin operating the hospital even before regulatory approval, but subject to that later approval. And the buyer will, in that regard, have to pay and finance the operations. Potential result of the process here is there could be a sale to one buyer of all the hospitals. There could be a sale to no buyers, which obviously would be bad. There could be a sale to multiple buyers. If there is a hospital or multiple that are not sold, there will be an attempt to see if Steward can keep those operating on their own. Based on what we've seen in the bankruptcy filings so far, it doesn't seem that likely, however. Next slide, please. This slide provides a lot of the specifics of the bid deadlines. I'm not going to spend a lot of time on it. Just note, as I said, the deadlines are coming up. The bids are due on July 15th, and the sale hearing is July 31st. That's the extended schedule I mentioned. Next slide, please. The sale is being marketed in a couple of different ways. There surprisingly is a different marketing for the northern hospitals in Massachusetts from the southern hospitals. And bidders can do a whole variety of things. They can bid separately for any one hospital or any group. Bidders are permitted to negotiate directly with the landlord, with the unions and their pension funds. And to the extent a bid is received from a lender, the lender can include a credit bid. The concept of a credit bid is that the lender is entitled to be paid money. So instead of the lender paying money and then getting it back, they're entitled to get a credit from their bid. Next slide, please. This slide and the next one talks about all the specifics that are required to be included in the bids. A 10% deposit, the bids must be irrevocable. They have to include an asset purchase agreement. There can't be any financing or diligence or other approvals that are contingent. The bidder has to determine and indicate how they're going to treat employees and employee benefits. Next slide, please. The hospitals, if the bidder bids for more than one, but less than all the hospitals, they are required to include an allocation. The bidder has to agree to a transition services agreement. The bidder should identify the contracts and or leases it intends to assume or assign. As I mentioned, the bidder can reject a contract. Assume and assign is the opposite. This is when they will accept a contract, and they are permitted to do so even if a contract or a lease prohibits assignment, because that is a specific right under the bankruptcy code. Bidders will have to demonstrate their ability to consummate the sale and also include adequate assurance information. That goes along with showing they'll be able to close the sale, but relates specifically to contracts and leases that they are going to assume. One other thing I wanted to point out is the bankruptcy court has entered an order providing for mediation among the debtors and MPT, their landlord. As I mentioned, MPT had provided financing and also believes it is owed money on a senior priority basis to the lenders. In this situation, that's going to be an issue that will be addressed first by mediation. And that's something that happens quite often in bankruptcy courts. The judge who has been assigned as the mediator, a different judge than the one who is handling the case, is very familiar with hospital bankruptcies and has acted as a mediator in many similar situations. So there are a whole bunch of questions. Many of them I didn't get to read. So I'll turn it back to Eric and he can address the questions on his side of the table, and I'll try and catch up on the other questions.
That sounds good. Mike, unless you want to direct me to questions, I can take a few.
Yeah, please do. In fact, I think we had so many questions that my chat boxes seemingly crashed here. So if you want to run it through, first, just to kick us off, one that I think was touched on a little bit, but I think it's Schuyler here. In these types of cases, Schuyler, does the judge come in with an inherent bias in favor of keeping these open as hospitals, right? Are they looking for a purchaser who is going to maintain the hospital role in the community, or is he just looking for the best deal for creditors at the end of the day?
Yeah, very good question. And the answer is the judge is very concerned about keeping hospitals open. He has expressed that repeatedly, and Steward has expressed that repeatedly. And I mentioned Steward in this situation because the way it works is Steward makes the first recommendation to the court. And the court then, in most instances, will follow the debtor's recommendation. If there are parties who object to it, then the court will consider the reasons for the objections. But in most instances, it is the debtor's recommendation that is relied upon by the judge. Mike, I see one question there. Has any hospital system in this predicament successfully sold their hospitals? The answer is absolutely yes. Unfortunately, none of them are particularly coming to mind, but I've been involved in probably 15 or 20 that have. I was involved just recently with a hospital in Iowa that was just one, but they did successfully sell their hospital, and I've seen a lot of others.
Yeah, there was a question about sort of, can the state force the hospitals to stay open? The answer to that is no. There's not a provision in state law that allows the Commonwealth to require that any hospital remain open. And I think there are probably good reasons for that. I mean, when hospitals don't have sufficient funding, they can't safely operate. The state can't do that. There was another question about the authority of the Attorney General and sort of the breadth of its authority as it relates to um, mergers, and the Attorney General's antitrust authority is quite broad, but in this scenario, I think it's focused on the potential anti-competitive effects of mergers. But certainly, if an individual or another fund or wealthy purchaser sought to purchase one or more of the hospitals, the Attorney General's office could look into that. But the antitrust concerns are less than if it's someone who is already in the healthcare arena.
And Eric, another question is, are market reviews conducted? The way it works is there is a competitive process. Folks are required to submit a bid for the first group, July 15th. The debtor will then look at all of those, determine what they think is the highest and best offer. And if there are multiple offers, they will conduct an auction. And so it is that way that the ultimate highest price is addressed. Another question as to guardrails for future. That is where the state regulators still have a position, and if they are concerned about that, can refuse to approve or approve only under certain conditions. Another question is private civil actions. Generally, those are things that would be conducted by an investigation, would be conducted by the creditors committee, and they will then have the authority to bring those actions. It's fairly typical in a situation like this for lawsuits to be brought against management to recover.
And there have been a couple questions about whether the state could come in and purchase the hospitals or take them through eminent domain. I think, the state could be a bidder for the hospitals theoretically. I think from the reading that I've seen or the statements that I've seen in the media that the legislature has not appropriated those funds, and I think that would need to be sort of a prerequisite to it. I'm not aware of sort of tens or more millions of dollars that EOHHS or other state agencies have at their disposal to purchase these hospitals. But it's something that, and certainly there are, a few hospitals in Massachusetts that the Department of Public Health runs.
Another question is, how will the fact that Medical Properties Trust owns the properties affect the bidding? That is something that is certainly a concern. The bidding process is set up to include a potential purchase from NPT. And it also provides for bidders to negotiate directly with MPT. It would be very difficult without their consent, without MPT's consent, to force them to sell unless there is a provision in the leases that gives an option to purchase. Unfortunately, we haven't seen the leases, so I can't comment on that.
There were a couple of questions about the stewardship health to clarify that is the physician group, and sort of what if anything is sort of tying the individual physicians who are part of that group to it and with a sale. And I haven't reviewed the individual physician agreements, but I suspect that they have agreements for a particular term with the physician group. But also, I suspect, like all of us, they can't be forced. We don't have indentured servitude in the country anymore, so you can't be forced to work for a particular employer against your will. So there's certainly, I think, in this case and in many other bankruptcies, it will be the organization Steward is incentivized to try to keep its physicians there so that it can operate the hospitals and then eventually sell the physician group separately. And then the purchaser will want to do everything it can to keep those employees there as well. I don't know, Schuyler, if you have anything to add about that, about
Yeah,
how
that's
this
absolutely true.
sale of
And
groups work.
certainly I've seen a bunch of sales in bankruptcy court where there were physician groups involved. Frankly, not one as large as this, but the buyer understands what they need to do typically, and they come up with an incentive plan for the employees that they need to make sure that they can successfully run the business going forward. One question was with regard.
One I saw in there earlier relating to at least two of the hospitals, the Boston Hospital, St. E's and Kearney, training sites and train residents and fellows. Do they have a voice in these proceedings at all? What sort of security can they have in their future training?
Can't say that they have a particular voice, but to the extent they're being mistreated or not getting what they are required to be provided, either in terms of training or financially, they can come to the bankruptcy court and or work with the patient care ombudsman to address those issues. It certainly would not be the first time that happened, but also would not be the first priority of the judge.
Eric, I don't know if there was any other key ones in there that you saw. Flipping through here is payer agreements. What happens to the sort of the contracts that the hospitals have with respective commercial payers?
Yeah, to the extent those are contracts which the buyer views as favorable, they're going to want to assume those. To the extent the buyer has its own payer agreements with the same parties, they might not assume those and might go on with their existing agreements. And in that situation, the payer agreement would be rejected. The counterparty would then have a claim in the bankruptcy that they could assert for damages.
And if we have time, there were just a couple questions asking about like the logistics of the antitrust review, right? So, I mean, normally antitrust regulators don't begin a review until there is a preliminary agreement between the proposed merging parties. So here with the hospitals, because this is effectively an auction, it would be unusual if the antitrust authorities had already begun or had done detailed, extensive investigations or reviews of potential purchasers already. But on the other hand, this process is going to move quickly, and you would think because the proposal is for the steward to seek the court's approval subject to regulatory review, that potential purchasers who believe that there's some risk of the government viewing them as subject to antitrust scrutiny would want to get ahead of that and have conversations with the regulators and start to disclose early, so that when if their purchase is approved, it could be reviewed quickly and a determination made early. The worst case scenario, right, is a purchaser being approved by the court, and then some weeks or months later, the Department of Justice or Federal Trade Commission determining that they need to sue to block that merger, and then you're left with no potential acquisition.
In two more, I see, can they hold the current CEO accountable? Yes, the creditors committee will be authorized to bring lawsuits against the current CEO and anybody else they feel has done wrong, and to the extent they're successful, can get their assets, yacht, etc. Question, would you imagine MPT is therefore the most natural stalking horse? I actually don't think so. I have been in a lot of cases where MPT was the landlord, and I have not seen them act as a purchaser. You need an operator here who can really run the hospitals and be efficient in doing so.
So, Mike, we're at time or maybe over time. I don't know if you want us to try a few more of
I
these.
wish we could get to all of the questions in the chat. There were a lot. I think we're going to look for another opportunity to engage the two of you, because this is certainly going to be an ongoing concern in the weeks and even months ahead as this continues to play out. So I hope we can return to you to provide some perspective to our members, and we'll do our best to see if we can maybe get some of the questions packaged up in a fashion that we can share back with the audience. We got a large audience today, so we're doing our best to accommodate as we can, but we certainly want to make sure that folks get their questions answered at the end of the day. So guys, thank you so much for joining us. A lot of great information here today, succinctly packaged, and I think very helpful to those watching. I also want to thank all who tuned in today. We got a QR code coming up on screen now that shows all of MHA's upcoming educational programming. In particular, we'd like to invite you to register for next month's Workforce Summit, where we'll be exploring the challenges and creative approaches to growing and supporting our healthcare workforce. We also have a number of other events this summer and hope to see you again soon at one of them. Hope you all have a wonderful afternoon. Thank you.
Thanks, everyone.
Thanks very much.